This conference will now be recorded.
So I'd like to welcome everybody who's joining me this afternoon on April 9th, 2021 for our topic, 5 Reasons You Need to Create a Special Needs Trust for a Beneficiary with a Disability. So it's really important to become informed consumers because the correct information empowers us to make good choices and good decisions, rather than avoiding the issue, not having the conversation, and not doing proper planning. So when we do have a family member, a friend, a loved one who has special needs or has a disability, it's even more important to plan ahead. Many families struggle with the concern whether their loved one's needs can be met by government benefits alone. And for many people, the answer is no. The government benefit programs, whether it be SSI or Medicaid, is not enough. So planning ahead both legally and financially is important to provide that nest egg, so to speak, of additional funds that are going to provide your loved one with quality of care and quality of life. Believe it or not, I still get the question, should I disinherit my loved one who has a disability simply because they have special needs? And the very quick answer is no. That was something people did 20, 30 years ago because there really was lack of information back then about special needs trust. So people did that out of fear and not having correct information. But there's no longer a need to do that. In fact, today we're going to talk a little bit about how that's dangerous. That if you were to disinherit a loved one with a disability and instead you leave more of an inheritance to somebody else in the family with the expectation that they will use the assets for this person, there is no guarantee that that's actually going to happen. From a legal point of view, the beneficiary that receives the assets is under no legal obligation to share it. And it becomes problematic if that beneficiary were to get divorced, because then in the divorce proceeding, that inheritance would have to be reported. So it truly is a better approach and a better plan to create the special needs trust. So as I just mentioned, if you leave more assets to somebody else in the family, they could get divorced. You also run the risk that if they're not fiscally responsible, or let's say they have credit card problems, they're living beyond their means, that money that you had hoped would be shared with your beneficiary who has the disability is lost. So here are some very good reasons to create the special needs trust. And the first is we certainly don't want our beneficiary to lose any government benefits they're either receiving or they're in the process of applying for. So certain government benefit programs have financially sensitive eligibility requirements, meaning that people have to have low income as well as limited resources in order to qualify. And some examples of those programs include Medicaid, which helps to cover healthcare costs, the SSI program, which provides people with a monthly payment, food stamps, which is a way that people help buy food, and HUD or Section 8 housing, which is a subsidized housing program. So we don't want our loved one to lose their benefits because that just means any inheritance they receive is going to be depleted more quickly. Our goal here is to allow the special needs trust assets to supplement, not replace, the government benefits and hopefully extend them a lot longer. A second reason to create a special needs trust for our loved one is because we are also creating a management system. What I mean by that is we're naming somebody as a trustee that we feel is mature and responsible and is going to make good decisions. And so that becomes a management system for the beneficiary who maybe themselves is not going to be capable of properly managing their inheritance or might be susceptible to being taken advantage of once they receive the inheritance. And this really leads us to the third reason to create a special needs trust is that some beneficiaries might become that perfect victim of financial exploitation. Either by the way they act or they speak, they are viewed as somebody who may not have the mental capacity to know that there's a scheme or a fraud that's taking place. And a very good fourth reason to create the special needs trust is because we all want our beneficiary to have a better life. And being able to afford certain services or products can achieve that quality of care and quality of life that may just not be available under the current Medicaid system. And last but not least, by creating the special needs trust from the beginning, it helps you and the family avoid both the financial cost and the emotional stress that might have to be corrected if a mistake is made in the beginning and there is no special needs trust. So that can save time and it can save expense and avoid the emotional stress. So let's start with reason number one. We want to avoid the beneficiary losing government benefits. So we're going to talk about what we call a third-party special needs trust. Third party simply means that the person creating the trust is not the person with the disability. It's somebody else. Somebody who very likely does not have any legal obligation to support the person who has the special needs. So when we talk about a third-party special needs trust, it means that the beneficiary will not have any control. They won't have direct access to the funds. And for this very important reason, the Social Security Agency and the Medicaid agency do not count the assets in the trust as being available. That's why this is such a wonderful planning tool. The government knows the special needs trust is there. They know your beneficiary is going to benefit from it, but because they have no control and access, it doesn't interfere with them continuing to get their government benefits. Now, when I say there's no support obligation, we're primarily talking about somebody who has no obligation of support to another adult, meaning the beneficiary is somebody over the age of 18. So what happens if you have a beneficiary you want to name in a special needs trust, but they're under age 18, they're a minor? Well, we're going to first look at what is your relationship to that person. Are you a parent? If you're a parent, you're considered to have an obligation of support till 18. It doesn't mean we can't write the special needs trust. It just means that perhaps we have to word it in a slightly different way. If, let's say, you're a grandparent, under Florida law, you don't have any legal obligation of support. So that's fine. Now, it's very important that you not only think carefully about who to name as the trustee to administer this special needs trust, but you also want to think about a successor trustee just in case the first person you've named gets sick, unanticipated. You want to have that management system of continuity. You also get to choose who is going to be the remainder beneficiary when the person with the disability passes away. So if there are any assets remaining in the special needs trust at that time, you get to choose and direct who inherits. What's left is not going to go to any government agency. So I want to repeat that again. With a third-party special needs trust, anything left in the special needs trust at the death of your beneficiary is not going to go to Medicaid, and it's not going to go to the Social Security Administration. So you can decide if you would like it to go to a charity, would you like it to go to a person, or perhaps a combination of both a charity and other people. This type of special needs trust can be written in several different documents. It can be written in your last will and testament, which means that the special needs trust is not going to come into being until your demise. Or let's say you have a revocable trust that was created because you want your assets to avoid probate when you die. It can also be written inside your revocable trust. Similar to the will, it means that the special needs trust will not be funded and will not come into being until you pass away. Now, the one exception to this rule that I'm going to mention is if you have a spouse and your spouse is receiving government benefits, or your spouse has been diagnosed with a chronic condition and you're anticipating that perhaps in the future your spouse would need to qualify for Medicaid assistance, then the rule changes and the law says we have to write the special needs trust for your spouse in your last will and testament. It's still going to achieve the same goals and provide the same protections. Now, special needs trusts can be funded with a variety of different types of assets, so it doesn't have to be just cash. It can include real estate, such as a home or rental property. It could be funded with proceeds from a life insurance policy or an annuity. It's even possible to designate a special needs trust as a beneficiary on a retirement plan, such as an IRA or a 401k, but we get into some tax issues that really do need to be addressed with not just your attorney, but your accountant or your tax advisor. So keep that in mind that a lot of different kinds of assets can fund the special needs trust. A second reason to create the special needs trust, as I mentioned, is you want a management system, a way of being assured that the inheritance is going to be monitored, invested, and handled properly for your beneficiary. So it's very important that there be documentation each year as the trust is being administered. Now, why would this be important? Well, there's a couple of very good reasons. One of the most important reasons is that it is possible that at some point in time, either the Social Security agency or the Medicaid office might ask the trustee for a financial accounting. They might want to see what the money is being spent on to make sure that it doesn't in any way violate their rules. So it's a very important reason that the trustee maintain good documentation. Well, what does that mean? That means we'd like the trustee to use some sort of a software, whether it be Quicken, QuickBooks, Excel, as well as scanning the documentation as to the types of purchases that have been made. So that would mean scanning an invoice or a bill of sale. That way, if they're ever called to produce an accounting, they have all the documentation necessary to make it an easy process to get through. An organization really goes hand in hand with the duty to document. So I do recommend, if somebody is not computer savvy, that the trustee work with advisors who can not only provide the necessary hardware and software, but teach the trustee how to use that technology to be organized so nothing is lost or misplaced. Having a management system also helps create an order, a way to prioritize. And we like to start in the very beginning when a special needs trust is first funded to identify what are the priorities for this beneficiary. And part of that process means that we put together an expenditure plan. What is needed on a monthly basis and what might be needed just annually. So that could mean everything from medical treatment that's not paid for by Medicaid. It can also mean that we have to make sure there are funeral arrangements put into place early so we don't run out of money to take care of that later. It might also include vocational training, tutoring, as well as vacations. And it's so important for the trustee, along with the beneficiary, to maintain open communication with the government agencies. We always want to be transparent. Nothing about the Special Needs Trust Administration process is hidden. It's completely transparent and everything's documented. One of the challenges that we hear from beneficiaries and trustees has to do with the day-to-day types of purchases that are needed. A trustee may say, do I need to always go food shopping with the beneficiary if they're capable of doing it themselves? Or do I need to go with them shopping to buy clothes or shoes? And the answer is no. And there's a really great solution that makes this a very easy process. And that is what's called the TrueLink card. This was developed years ago by a company out in California. And what I like about this TrueLink debit card is it acts in a very different way than your standard credit card or debit card works. When setting up the TrueLink card, the trustee is allowed to indicate what kinds of purchases can be made, as well as the types of purchases that cannot be made. And the reason for this is so that we stay within the SSI rules if the beneficiary is an SSI recipient, as well as staying within the Medicaid rules. Also, it allows the trustee to exercise that control and supervision in the event that a beneficiary has other challenges, which might include any kind of alcohol or drug addiction problem. So the trustee could indicate, for example, that this TrueLink debit card cannot be used to buy alcohol, or it can't be used for gambling. And you can also set a limit on the categories where the card can be used. So I have found that this is a wonderful tool, not just for beneficiaries of special needs trusts, but sometimes for people who have compromised cognitive abilities. We don't want them, first of all, to purchase things they don't need, nor do we want them to be encouraged by somebody who might have ulterior motives to buy things that are really not relevant. Now, the third reason and benefit to creating a special needs trust is we want to protect our beneficiary from financial exploitation as well as creditors. And financial exploitation is something we're seeing as more of a challenge, especially this last year with COVID. When people are alienated, they're having to stay in their home or perhaps the residential community where they're residing. There's a lot more fraud going on through cell phones, through internet, through email. And so the Special Needs Trust is a very good way of making it difficult for those people that are committing the exploitation and the fraud to get their hands on the assets, because your beneficiary is not going to have any direct access or control. You know, we sometimes use the phrase that they can stand on their head, which they might do if they practice yoga, but there's no way that they're going to get their hands directly on the assets. So it also ensures that the assets are used for their intended purpose. And one of the things that makes the Special Needs Trust work in a way that your beneficiary won't lose their government benefits is your trustee is going to be instructed that when a purchase is made, they are going to pay the vendor directly. They're not going to put the money into the hands of the trust beneficiary and expect the beneficiary to then pay the vendor. So we want to go directly from trustee to vendor. Now, what if your beneficiary has creditors? Maybe on their own, they've got credit card debt or medical debt. Well, guess what? That debt is going to be protected from the Special Needs Trust assets. And so this ends up, for that reason, being another very good tool. Now, if the beneficiary happens to be married and they then go through a divorce proceeding, so far to date, the case law is that the assets in the Special Needs Trust are not available to the divorcing spouse. It is what we call an irrevocable trust. So once made, it cannot be undone. It can't be broken by a court. So as we have the conversation and we're planning ahead by considering a special needs trust, we want to think of what are the things that my beneficiary is going to be able to get as a result of my creating a special needs trust for them. And this is a very broad standard. It's as if I'm giving you a blank canvas with several colors of paint to choose from and several paintbrushes, and you can have an unlimited list of possible things that the money can be spent on. So there is no rule that says you can't spend the money on food, or you can't spend the money on shelter expenses such as rent, mortgage. That is a very bad rumor that has been spread, so I want to make sure we undo it. What you want to understand is that if the beneficiary receives SSI benefits, we have to make the trustee aware that if there's a need 1 month to use special needs trust assets to buy food for the beneficiary or pay housing expenses, it does need to be reported to Social Security. And for that month, it is going to cause a reduction in the SSI benefit by approximately 1/3 of what the beneficiary would normally receive. So for this year, that reduction is going to be approximately $281. Now, as long as the beneficiary is going to be left with at least $1 of SSI, they're going to keep their Medicaid, and it's a win-win situation. So what the trustee needs to evaluate is there more benefit to be achieved by using special needs trust assets to pay for food and shelter than the benefit of the actual SSI check? And so we have to go through that analysis with each beneficiary, because each beneficiary might not be receiving the same amount of SSI. And we have to look at what's the overall goal and the overall benefit. So I've given you a few samples of what people have spent special needs trust assets on. Housing, as I mentioned, could include paying a mortgage, paying rent, paying utility. Transportation, buying a vehicle. Now that means even though the beneficiary might not be able to drive or might not have a driver's license, we're going to have somebody who is a responsible driver take them to their doctor appointments, take them to social events. It can even include buying concert tickets, things that are going to give them that joy, that quality of life. It can include going on a vacation. And if your beneficiary needs private duty care, which is certainly not covered by Medicaid, the trustee can hire a private duty home health agency. We've even seen younger beneficiaries who have college education or technical degrees want to start their own business and see if they can start to support themselves. These are all permissible uses of special needs trust assets. So in continuing with reason number 4 of why we want to create a special needs trust, I'd like to run through what I call the 10 commandments of administering a special needs trust. And we already touched on the first one, which is that the trustee is going to make the distribution directly to the vendor, not go through the hands of the beneficiary. The second commandment is what the law calls the sole benefit rule. And very simply, the sole benefit rule means that when the trustee is deciding, should I make this expenditure? The question they ask themselves is this expenditure for the sole benefit of the beneficiary? Now, sometimes when we answer that question, there are going to be other people who receive a benefit as well. So let me give you an example. Many times a beneficiary may not have gone on a vacation. And so one of the very first requests a trustee might receive is to take the beneficiary to Disney in Orlando. But the beneficiary has some physical challenges, physical limitations, and they can't go themselves. So perhaps somebody else in the family is going to accompany them, and the request is made to pay for that other person's admission to the park, their hotel room, and their meals. Now, Social Security has gotten this question so many times in the past that they actually have a commentary written on this. And the commentary says it's fine to pay that other person's expenses, but we can't go beyond that. So let's say the person who's the caregiver then says, I would like the special needs trust to pay for both sets of grandparents to go and all the first cousins. At that point, the trustee has to say no. That is no longer for the sole benefit of the beneficiary. We can only pay for the caregiver. The third of the 10 commandments is the importance of maintaining good records, and we also touched on this because we never know if and when the government agency might ask for an accounting. And that leads us to the fourth of the 10 commandments, which is get into the habit of preparing an annual accounting And that way you're never caught off guard and you don't have to play catch up. The fifth of the 10 commandments is to prepare that expenditure plan in the very beginning. Have that monthly budget. Know what is expected, because that also helps when planning on the type of investments. Then we know how much income needs to be produced to meet those expenditures. And the expenditure plan should be reevaluated every January, because we want to revisit. Have expenses changed? Has income changed? Do we need to change the investments? The sixth of the 10 commandments is that it's okay to pay shelter expenses. And we talked about this on the last slide when I said it's okay for a special needs trust to pay for food. Your beneficiary can go out to a restaurant and enjoy themselves. It's also permissible to pay any kind of housing related expenses. The seventh of the 10 commandments is we definitely want the special needs trust to pay for non-shelter types of expenses. So think in terms of your beneficiary would benefit from a computer, having a scanner, having a tutor to teach them how to use it. Perhaps there is some specialized new advances being made in medical equipment. And many times we find this is being created in Europe, not in the US. So we're going to purchase that equipment. We're going to have it shipped. Anything that is going to improve the quality of life, quality of care for your beneficiary is a permissible use of assets. While it's never a pleasant topic to discuss, many people are uncomfortable talking about death and mortality. I will share with you that when your beneficiary receives SSI, there is a very important SSI rule we have to be mindful of. And the SSI rule says that if there are no pre-need funeral arrangements made prior to death, the trustee is not allowed to pay for funeral expenses when your beneficiary dies, because Medicaid must first be taken care of if the assets in the trust actually came from your beneficiary, such as through a lawsuit because they were injured. If it's purely a third-party special needs trust where you provided the assets, not your beneficiary, while we don't have to worry about any Medicaid lien, we also don't want to be in a position where there's insufficient amount of assets left at the end to pay for funeral arrangements. So I do encourage the trustee and the beneficiary to address this early on. Then it's paid for, it's taken care of, we don't have to worry about it later on. And another benefit to prepaying is that the trustee is locking in the cost. So should there be any increase, it's not going to affect this beneficiary. And don't forget about the importance of making home modifications. Home modifications means that we want to make the home safe and accessible for the beneficiary, whether it be wheelchair access, through a ramp into the front door, through widening hallways and doorways, especially to get into a bathroom. It might mean that if a beneficiary is in a wheelchair, we need to redesign the kitchen so that the counters are lower and more accessible to your beneficiary. These are just a few examples of the types of home modifications that can be made by general contractors that are trained to do this for homeowners with special needs. And then don't forget, we talked about the truing card. This is a wonderful tool that a trustee should consider using for their beneficiary. It gives the beneficiary a sense of independence, of dignity, of being involved in how the assets are used to create quality of life for them. And certainly not of least importance, but our fifth reason for creating the special needs trust from the beginning is we don't have to correct a mistake down the road, which can be difficult to do if you've already passed away and there is no special needs trust. And unfortunately, when that happens, we're left with having to go to court and try to explain to a court that it really is necessary to now create the special needs trust. That's just going to incur legal fees, which is going to reduce the amount of the inheritance you left. It also means that if we have to create a special needs trust after you've died, we then have the Medicaid lien to repay that could have been avoided. So one of my first tips is don't fail to update your beneficiary designations. What do I mean? Let's say you've come to me, we've written the special needs trust, but when you went home, you didn't change the beneficiary designation on your life insurance from being your beneficiary to being your beneficiary's special needs trust. If you fail to update your beneficiary designation, it could mean, number one, that it's going to go through probate. It also could mean that the money ends up going directly to the beneficiary. And at that point, it's too late. We can't put that asset into the special needs trust. It's already in their name. And at that point, it's a countable asset. It's going to impact their eligibility. We also want to be careful that you don't go to an attorney that is not properly trained in special needs trust and doesn't keep up to date with when the law changes. Because then what we see are special needs trusts that are written too restrictively. Years ago, I had a client come to me whose special needs trust for her child was written in a way that it actually said the trustee could not use special needs trust assets to pay for housing expenses, and they could not use the assets to pay for food. And we actually had to go to court, and we needed an expert witness to testify why this was restrictive and why the law actually allows special needs trust assets to be used for those purposes. But because it was written too restrictively, the client had to hire me, and that was an additional legal expense that could have been avoided. A third thing we want to be careful about is we don't want the special needs trust to require that income earned on the investments be distributed. Because if that happens and the income is distributed directly to your beneficiary, guess what? Now they have more income and it's countable. So we want the income to stay within the trust and allow the trustee to use it as need be to pay the vendors. Another problem we've seen when a special needs trust is written by an attorney that is not specialized is it uses the wrong standard. It doesn't say that the goal is to supplement, not replace the government benefits. An example of the wrong language is when it tells the trustee, use the assets for the beneficiary's health, education, their maintenance, or their support. We just killed the special needs trust if we use the word support, because that's not really what our goal is. Our goal is to supplement, not support. And then another thing to be aware of is properly fund the trust. Think in advance. What are the assets I'm going to designate to be used to fund my special needs trust? Well, funding has a lot to do with the age of your beneficiary and the anticipated life expectancy of your beneficiary. So this is where it's important to have all the right team members on your team. And your team includes not only the elder law attorney or the special needs planning lawyer, it means we need the right financial advisor and your accountant. Because part of adequately funding your special needs trust means we might need to explore the purchase of life insurance or other types of assets. So I'd like to leave you with a few tips to help you take the next step and get organized. We want to keep your momentum going after today's webinar. So the first tip is start to select your fiduciaries. Fiduciary is a word that means the people you're going to name as your trustee, who are going to be responsible for taking proper care of the special needs trust. You want to explore family members, friends, or perhaps even a professional trustee, such as a trust company. When you go with a professional trustee, you're getting the added value of a company that's been trained and provides continuing education to their employees on the rules of government benefits, not just how to properly invest and monitor the assets. Next, you want to identify your beneficiaries. And this might sound very simple, but you want to have a conversation with that beneficiary or their parents to understand, do they have a diagnosis? Are they already on government assistance? If so, what are those benefit programs? Is there a beneficiary who's capable of receiving their inheritance directly? They can manage it responsibly, and they don't have any government benefits that they receive. Many clients tend to think in terms of dollars when they're allocating their estate. I'm going to suggest that instead of working with dollars, you work with percentages. And the reason for that is if you leave somebody a set dollar amount, and on the day you pass, there isn't enough to go around to that beneficiary and the other people you've named in your will or your trust, it may mean that somebody actually gets cut out accidentally. So to avoid that happening, I suggest you work with percentages, and as long as all the percentages add up to 100, you will then be assured that all your beneficiaries are going to receive something. No one will be accidentally left out, and it'll be up to you how small or how big a percentage each beneficiary receives. My third tip is for you also, if you have direct care and responsibility for the beneficiary with special needs, that you prepare what is called a letter of intent. And a letter of intent serves the purpose of creating a running history of what's important for the care and well-being of this person that you're leaving behind. So you want to include information such as who are their doctors, who treats them, do they have any allergies, do they have any phobias, is there a particular religious observation you would like continued? What kind of lifestyle would you like them to lead? Would you like them to remain living in the house? Would you prefer that they live in a supervised community with their peers? So there's a lot of important information that essentially you want to download from being in your head to being on paper or on the computer. And I do recommend that you reread the letter of intent at least once a year and you update it, because this is going to be the guide that you leave for the trustee, or if there is a guardian for your loved one, the guardian needs to know as much about this beneficiary as you do. And of course, last but not least, start to meet with an experienced elder law attorney. Start to form your team of advisors, which includes the elder law or the special needs attorney, the accountant, and the financial advisor. And I'd like to invite everybody to join me next Wednesday on April 14th at 12:30 p.m. for our webinar to celebrate National Healthcare Decisions Day, where we're going to be talking about the different types of medical advance directives that everyone over 18 needs to have. So at this time, I'd like to open it up to any questions. You're welcome to unmute your microphone or feel free to write a question in the chat box. So if there are no questions, I have a few more tips to share with you because I know that sometimes we have people attending my webinar who are not necessarily in the state of Florida, but they need guidance on how to find and hire an elder law attorney in another state. So you want to ask questions such as how many years of experience does the attorney have? And what percentage is devoted to elder law compared to other areas that they might be practicing in? And if you're going to this attorney specifically for a special needs trust, you want to ask, how often are they writing a special needs trust? Are they aware of how the government benefit rules change? You can always ask if they're board certified, which means that they've gone on for additional experience and testing to be called a board certified elder law attorney. Ask for a reference, read their reviews. Now, if you're not in Florida, a good website to use as a resource is NALA.org. NALA stands for the National Academy of Elder Law Attorneys. You can go to their website and search for an elder law attorney in your geographic area, and it'll also tell you if that attorney is board certified. If you're in Florida, you can go to the floridabar.org website as well, and you can read the profile about the attorney. Have a consult. It's very important that you find a person you connect with, that you have rapport, that you feel comfortable with, that the person understands your concerns, helps you to identify your goals, and of course is going to keep everything that you share confidential. Now it sounds like somebody may have unmuted their microphone. Would somebody like to ask a question?
Hi, Stephanie. Thank you very much. It's very informative and helpful. The question I have is I'm guessing this is a PowerPoint, and if it's going to be available after the webinar as well as the recorded version of this presentation.
It is. We are recording the webinar, and when it is posted to the website as well as to YouTube, it's going to be a combined recording, meaning that it will include the audio, the PowerPoint, as well as a typed transcript.
Oh, wonderful. Wonderful. Thank you.
You're welcome. We have a lot. Yes.
Will we be sent the link for that, or we have to go somewhere to look for it?
You can go to the resource page on my website.
Okay.
And I would probably say it's going to be available late Monday or Tuesday.
Okay. Perfect. Thank you.
You're very welcome. We have a lot of great topics planned for May because May is traditionally known as National Elder Law Month. So I encourage everybody to go to the calendar page on my website. You'll be able to see the topics and to register. If for some reason you register, but then something comes up last minute, and you can't attend, just go to the resource page a few days later and you'll be able to access the recording. I see somebody has written a question in the chat box asking about the free document checklist. So if you go to the Contact Us page, it can be downloaded from there. I can also have my staff email everybody who attended today the gift certificate with the free document checklist. So I want to thank everybody who joined me today. I hope you have a wonderful weekend, a safe and healthy one, and that you will join me in the future. Thank you.